Hello, everybody. Hello, hello. Come on in. Come on in. Come on in. Come on. Oh, I'm sorry. I'm having trouble. Come on in. Come on in. Come on in. Good day. How's that brief? Come on in. We got people from San Diego. Of course, this thing's falling apart. Come on in. Swipe left, swipe right, up or down. You can share this on Twitter, Facebook, email, carrier pigeon, personal delivery, smoke signal, any way you want it. North Carolina, Boston, Sydney again. Keep on sharing it. Left, right, up, down, share. Facebook, Twitter, hi. Well, I think the mood on this, Indiana, Northern California, Kentucky, Toronto, Canada, Vancouver, Sydney again. Well, here we are. What are we talking about today? San Francisco, Oklahoma. We're talking today, Minnesota, yeah, New York City. We're talking today about the granting of Adnan Syed's motion to reopen in the beautiful city of Baltimore. So how many, Manhattan, yes. Osato, hi. Manhattan. Illinois, oh boy, we're all over. So big day, big day, big day. So I'm going to ask this just to get started out. A little poll thing. Hi. I'm sorry I didn't respond to your message. I've been bad at that, but I've been meaning to. Long Island. Oakland. Yeah, Oakland. I used to work in Oakland, right on Harrison and Grand, right across the street from the cathedral at a law firm there. So fond memories of Oakland. Coffee with a Beat is a great little coffee shop just down the way. Makes me think of the podcast Snap Judgment. Hello, hello. Well, I think we're in festive spirits today, aren't we? And we're going to talk about the granting of Adnan Syed's motion to reopen in the... Oh, just a minute. Let me turn this off because the song is going to play more music on YouTube, which we're not going to do right now. We'll have some more music later. Piedmont, California. Oh, yes. My sister-in-law used to live there. Beautiful place. All right, so in case you didn't know, Adnan Syed's motion to reopen was granted in the district court, which is great, a huge deal, a really, really, really big deal. So we're going to talk about that, and we're also going to have a toast later on. So I'm not saying you have to drink or whatever you drink. I'm a lawyer. Someone says what my job is. I'm a lawyer. So when do we go to court? Yeah, it would be fun to go, wouldn't it? I don't know that everyone's going to be able to. In any event, Moscow, someone from Moscow. It's state court, Baltimore. We're going to have a toast later, so if you have any kind of, whether you want to have a drink or coffee or whatever it is you want, we're going to have a toast together. You can say your own toast. I think it'll be one that everyone can join in and be something good for Adnan, for the family, for everything. So we're starting out. So what happened today? Someone's in Mendocino. That's great. Beautiful place too. I won't get into it, but when I was in college, I got kicked out of a place in the Russian River. I can never go back. Someone says I'm on their naughty list. All right, so we're talking about this. I'm going to try to hold this, see if it helps so we can stay on message. So we're talking about, now I'm trying to read it, what the court order says, what the state argued, what this means. What the court order said, what the state argued, and what this means. So what did the court order say? It said, okay, I'll hold it up and then I'll read it. Someone says they need legal advice. Well, I'm not the person for it right now. We're talking about the Adnan Syed case, and this is not the time to get into other things. So, it said, reopening is in the interest of justice because, I'd say, alibi failure with Asian McLean, the post-conviction prosecutorial misconduct, so that's one thing. And then 2, the cell tower reliability issue. And 3, cell tower reliability is tied up with ineffective assistance of counsel and prosecutorial misconduct during trial. We're going to talk a little bit more about what it means, but so what this says is the Asia McClain letter was a big deal, and Asia McClain not testifying was a big deal, and Christina Gutierrez's failure to call her as an alibi witness or investigate the alibi witness was a big deal. It wasn't a issue that was just something left to the discretion of attorney. If you don't do that, you're not only messing up, but you're messing up in a way that potentially deprives someone of their constitutional rights. So that's the first thing. And then to cell tower reliability, and that goes to, if you remember, in Adnan Syed's reply brief to the motion to reopen, where they, in an incredible coup, submitted the affidavit of the actual expert witness who testified for the prosecution. And if you weren't there at the time I talked about that, that is a tremendous feat. I just can't even imagine. I will talk about, remind me later about my public records request about Jada Lambert's case when we get to question and answer at the end. It'll be good. Where was I going? So we have the cell tower reliability. We have the issue of the expert witness on the prosecution that actually submitted an affidavit for the defense in the motion to reopen. Gigantic, earth-shattering. And, okay, let's say for a minute, think how much wailing and gnashing of teeth there is going on among the anti-Adnan people on Reddit right now. Now, I'm not one to say that we should revel in other people's unhappiness, but, insofar as you can, there are burning coals falling on their heads right now. They spent so much time and so much effort minimizing the expert witness's affidavit, and there was nary a word of that in the order. So we have the cell tower reliability. I'm going to try to block some of these people, but I don't know how to do it while I'm on, so I'll figure it out later. We'll just have to ignore them. It's just think about this as a real testament to what's going on and how well things are doing, that all these people are going crazy. That's what people do when they don't have real arguments, when their whole idea of the case, their theory of the case is, and I do mean Asia McClain, her seeing him in the library, but specifically Christina Gutierrez looking into that alibi. Their whole theory of the case is based on fantasy and dreams, the dreams of a madman. So it's gone, and all they can rely on are ad hominem arguments and just silliness. So we have cell tower reliability is tied up on the third part with ineffective assistance of counsel in prosecutorial conduct during trial. So that again is that not only do we have this not only is the court saying that this cell tower reliability thing, that's an issue, but the prosecutorial misconduct tied together with it is a problem. So what that means is all this talk about the cover sheets and how they got to be the way they are is going to be at issue in this case. Let's see. Oh, I can block the user. Oh, that was easy. All right. I was able to block the user. Okay. All right, I think I figured it out. So someone's blocked. Him and Colonel Mustafa. Okay, is this person going to be blocked too? Wow, this is easy. Let's see, anyone else to block? I don't think we need to block anyone else. All right, so there we go. So that's what the court said. And let's look about what the state said that's been rejected by the court. Oh, can you remind us of the expert cell tower issue? Well, the expert cell tower issue was in, I guess we'd say, let's say 3 parts. We could say the expert cell tower issue was, 1, ineffective assistance of counsel by, excuse me, I will back up and respond to what they're saying, that the expert wasn't told that the outgoing calls are unreliable, at least according to the, and I won't call it a cover sheet. It's not a faxed cover sheet. It was a cover letter that was faxed, which is different, right? This isn't just some thing like this that scrawled. You remember the old days when we all did faxes and you'd have some message scrawled on it that would come in? It's not that. You know, that would be somewhat understandable. It's a cover letter. Maybe it's boilerplate, whatever, but it's a cover letter that came with the material that was faxed. So I know they called it the cover sheet, but it's more. So what do we mean by the outgoing calls? Yes, so the expert, we would put it under prosecutorial misconduct and just general reliability, that the expert witness didn't know this basic thing about how the subscriber report was meant to be used. So there's that. And then there's the ineffective assistant of counsel component of it, which is that Cristina Gutierrez failed to adequately cross-examine him about the cell tower issue, whether it was the subscriber report or potentially more than just not having the subscriber report and putting it in front of him. There's a lot more that could be done. And I will say more, but I read this order very broadly, more certainly than maybe some of you will. And I will explain why. We will dig into it, and I'll read a few lines, and I'll tell you why I read it very, very broadly. Why I think, based on this order, that this is open season on a lot of the case. If Adnan's attorney decides to go that way, and he may not. He may want to keep it more limited, but he could do a lot in this. This could be a really interesting day. So what the state said. Okay, someone said, what exactly happened today? It's important. And I'm going to back up one more time. All right. I am Brendan Kenny. I'm a lawyer in the Twin Cities. I'm not on this case. I'm not even a criminal lawyer. So I just look at the stuff going on in Adnan Syed's case and talk about it, basically. So what happened today is, and I think it's good for all of us to rewind and talk about what happened today in the motion reopen. What was the, as we say as lawyers, procedural posture? The procedural posture was, do you remember when, and I know a lot of you are making comments, and that's fine, you know, for everyone else to see. If you really are interested in the question you're asking, and I don't address it in this part, I will have a question and answer part at the end, and I'll be happy to if you raise it again. But me, I'm not going to remember it. So the procedural posture was, do you remember when we were listening to Serial, and Sarah Koenig was saying, you know, there's this small issue of Asia McClain, very small issue. It's hanging on by a thread, and just a minute. Oops, I got to block someone else. Here we go. Wait, cancel, because I don't want to block the wrong person. Well, if the person says something else, I'll block them. I didn't want to block the wrong person by mistake. There's a small issue of Asian McClain. It's hanging on by a thread. That's all that Adnan has left, because everything else he's lost on. And that's true. That was how it seemed. That was, you know, I've talked about this, that quote, you know, there's a tide in the affairs of men, and the tide was definitely going against Adnan. This, just to say where things stood, just to put it in terms we can understand, a trope, you know, from a movie. You have so many movies where the good guys are out in the wilderness, right? They've whatever position they've been in, whatever, they've been knocked out. They're out in the wilderness. It seems like all is lost, but they're getting ready for a counterattack. You know, in the example I'm thinking of, I know it sounds super silly, is in the second G.I. Joe movie. There's a part where they go back to the Dwayne Johnson's like neighborhood, and they're holed up there with like getting some old computers, getting ready to take on Cobra. I know, super dorky, but that's the trope, right? And that's how it was. You know, everyone, his team, they were down to the last ditch. You know, in the last ditch, waiting. You know, and that was all they had until it was all over, game over. You know, absent some pardon or something from a governor. And yeah, the second was much better than the first G.I. Joe movie. And everything's changed. It's changed procedural, but the tide's turned. So that's where things stood. And then with the motion to reopen, especially based on this new cell phone evidence and more stuff that came out about Asia McClain, just everything that happened in the case, suddenly this case is broken wide open. Wide open. To give a sense, I mean, let's talk a little bit, just quickly, about appeal and standard of review. And the way it works is the reason why it's so important that you get a good trial lawyer, whether you're civil case or whether you're criminal cases. Once you lose that, it's very difficult to do much from there. Because the appellate court, and thank you for sharing, John Ting Law. Anyone there who thinks this is interested, who wants to bring people in, just swipe left or swipe right, up or down, and there's a share button. You can share on Twitter, Facebook, email. So you're in a position when you're on appeal where you're pretty much stuck, in most cases, with the facts that you had at trial. And facts at trial, the deal with a trial is that a trial is to decide questions of fact. So if there's a question of law, for instance, like what you think of like the statute of limitations or something, like there's a 4-year statute of limitations on a product liability case. And you can show easily, there's no question, that the plaintiff filed it 5 years later. Well, as a matter of law, the case is gone. A question of fact would be, did the doctor, behave according to the standard of care or whatever in the surgery? And you have to have an expert witness and whatever. So that's in a civil case. But cases are tried based on facts that could go either way, based on the testimony. And typically the jury is the one who makes that determination. So when a jury issue, you almost say, is up on appeal. Thank you for sharing on Twitter, Sean Daly. When a jury issue is on appeal, it's very hard to win. And if you could find some procedural evidence problem, that's really your best bet. Well, in this case, so many of those things had already been rejected. Whether it came, the issue of Asia McClain already, the issue of ineffective assistance of counsel, a lot of they were essentially gone. Most of them were gone for this case. And reopening changed it. Why did reopening change it? Because what reopening allows you to do is create new facts. You're not stuck just with the facts at trial. So the fact at trial was that Asia McClain was nowhere to be found. Adnan had no alibi witness. Well, now he's got one. So this is as close to a do-over, undisclosed 3 time machines, send them back to Baltimore 1999 with his counsel and race into the court, have Cristina Gutierrez involuntarily retired and try the case. I mean, it's almost that big. So I may be exaggerating, but I don't think much. And what the court said today is you can do that. So that's where we're at. So what did the state say? This is, if I could just have a moment, I'm a lawyer, and when I started out, and for a while, we would write a lot of reports to, okay, I'm trying to block this person, and I don't know why it's not working. Oh, there we go. All right, so blocked another. We would write reports to the client about witnesses, usually, and we would use understatement. I don't know why, but it was always fun. So if someone had a terrible memory or we thought they were a liar, we'd say to the client, Mr. Smith is a poor historian. And also in some cases, you'd say something like opposing counsel says something and you win. And you want to revel in it a little bit, you'd say, opposing counsel was a poor prophet. And in this case, the state was a poor prophet. So what did the state say? And I'm sorry about the handwriting, Cristina Gutierrez had strategic reasons for not calling Asia McClain. And remember the strategic reasons, I'll talk about that in a minute. what the defense is doing is an unmeritorious campaign to relitigate the Sixth Amendment issue and smear the reputation of defense attorneys. It's funny, they're guardians of the reputation of criminal defense attorneys. That's their job as officers of the court, to protect the reputation of Cristina Gutierrez. And I don't know that this really comes up under an actual bullet point, but they said that they could have changed the timeline. No, so the state didn't say that today. This was what the state said in their opposition, if you remember way back when they filed that opposition. So unmeritorious campaign to relitigate and license to smear reputation of defense attorneys. So what do they mean? Excuse me, I've got some coffee here. An unmeritorious campaign, So, what they mean is, strategic reasons. Oh, unnecessary theater. Yeah, they said that too. It's the tone of their brief was all wrong. It was well written. It was the best they could do. It was underhanded, but the tone was all wrong. It didn't fit at all. I don't know that they could have done any better, but they really threw their best at it. So that was the best they could do, and it made for some interesting reading. Strategic reason. So their strategic reason is, if you remember, they said about the 81st witness. Terrible argument. And I just think some of these arguments just had to be for public consumption. A terrible argument, because they said, there was this letter that Cristina Gutierrez sent us, and it had a list of 80 alibi witnesses. And so, I should diagram this because it's really hard for me to even get in my brain. We'll talk about the shifting thing. That's just so terrible. But they said, because she told us she had these 80 alibi witnesses, she obviously was doing a good job, and so we should presume that she had an 81st. Which doesn't make sense, because this is just kind of some form letter that lawyers send all the time. Means really nothing. None of those people, most of them weren't even players in the case. And even if that wasn't the case, if this letter that Cristina Gutierrez sent, that we're going to use for evidence that she investigated all the alibi witnesses, didn't contain Asia McClain, how could we infer that Asia McClain, that she investigated? So it was really a silly argument. And then they said some asides about, she was a skilled defense attorney, which, as I've said again and again, if opposing counsel is telling me or saying to somebody that I'm doing a good job, unless it's outside the context of the case and we're friends or whatever, if they're saying that, I'm doing something very wrong, because there's a strategic reason for them to be saying that. And if they say you're doing a good job, it's usually because they're trying to get money from the court in a civil rights fee-shifting case, which I've been on the other side of. It's like, I should take some of the stuff people said about me or about us and put it as like a bio note, and maybe an endorsement, recommendation on LinkedIn. Take it and just put it as a recommendation, even though it was in a motion to get money from us, to say that they're entitled to attorney's fees. In any event. 2, so the unmeritorious campaign to relitigate and a license to smear the reputation of defense attorneys. So what they're trying to say, what they were arguing, is that, look, even if we could, this is the way I'm putting it, is what they're saying. They're trying to hedge their bets and say, even if you reopen it, you got to keep this really, 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 really limited. And the only issue would be, let's get Asia McClain in here. We can talk to her, we can cross-examine her, and you can decide whether what she says makes any difference. So when you're a lawyer and you're arguing that something is a re-litigation of something, typically it's a way to limit, to put a frame around what's actually at issue and limit what the judge is going to do, which didn't work out and could have changed the timeline. The judge didn't address that at all. That is one of those arguments that maybe it's actually true based on the law that that the prosecution could do that. But why on earth would you ever say that? I mean, that makes you look tremendously bad. But I think that's the thinking. You remember in the Intercept interview, do you remember in that interview when Urich talked about collateral facts versus material facts? Which I've never heard anyone use those terms. So just so you know, that's not a term of art as far as I know in the law. It's just a made up term that Urich had to say, our position is if we think we got our guy, the facts don't matter. We just get him. So as long as Jay said that he did it, that's all we care about. Everything else is collateral, which is terrible. And it shows a real lack of observation. I don't know that you think that would be a good argument. But when you have no other arguments to make, you make every argument you have. So that's could have changed the timeline. So, where are we now? What's our third part? Our third point. Act 3. I'll do This American Life. Act 3, Act 3, Act 3. What this means. What this means. Oh, right. Wait, actually, I'm going to do one thing. I want to get some response from you guys, a few things in response. And we're just going to do this by you, when you put a remark, just doing a 1, 2, or 3. So I just want to know kind of who's here and where you're at. So I'm going to do, it's going to be as 1 is going to be I read the whole brief. 2 is going to be I read some of the brief. And 3 is going to be I didn't read the brief. And no judgments. No judgments. Because who reads this stuff, otherwise? We got ones. We got ones. Don't say 3. Come on. You can do it. You can do it. It's fine. 3, that's fine. That's fine. Good for you. Good for you. Ones. We got ones. We got all these people who read the whole thing. Wow. Wow. 2s, 3s. That's fine. You don't need to read it. You don't need to read it. It's only been out like 3 hours. It's been out 3 hours. Okay? So we're not judging anything. I'm just trying to get a sense of it. And now, okay, I'm going to let you guys fill in, and then I'm going to ask another question. Because I want to know whether there's been a progress. Someone read it twice. Okay. KNW 185. That's great. Someone read it twice. Very short. Yeah, it's short, but it's not like, let me say, I'm into plain language in the law. It's not a plain language brief. There's not like a lot of bullet points, and it's not the way that I would want to write it. But whatever. No argument. If the judge is reading it, you're a wonderful person. We love everything you do. So we're not criticizing it. But okay, and I'm going to ask you this, because I want to get a sense on kind of the people who are on here, how involved you've been for how long. So let's talk about the state's opposition, the one that had all that stuff I've been talking about, the arguments they made about the cell towers, the subscriber reports. How many people, we're going to do 1, 2s, and 3s. How many people read the whole thing? How many people have read part of it? How many people have read none of it? So I just want to see if there was maybe a progression. So, and this is the state's opposition back in September. So how many people, 1, the whole thing, 2, part, 3, none. All right. So we got a lot of people who read that too. Wow. That's interesting. Yeah, keep them coming in. Yeah, that's really interesting. I mean, I hope you find it helpful, because it gives you a sense on who the audience is, who the people who are here. And I can tell you, if there was some place like this for people in the anti-Adnan and not as guilty camp, if they answered honestly, they could not give an answer like that. They couldn't. They could not give an answer like that because they haven't read it. Almost none of them, I'm sure. I won't say sure. But, okay, what this means. So we're going to do our little field trip part of this. And by the way, we are going to do a toast a little later to Adnan, to Rabia, to Undisclosed, to everybody. We'll just cover the whole gamut. And I'll ask you to just, if you want, do some of your own toasts. Short toast, right? But your toast. We're going to turn this thing around, go on our little field trip. I'm going to read you a few things about what the court said so you can see where I'm coming to the conclusions. And the conclusions I'm coming to is that this hearing, it's really the decision of Adnan's attorney how much he wants to cover, because it's open season. So let's turn this. Okay, so we're going to flip it. Oh, how are we going to do this? Yes, we're going to flip it. Oh, no, we're going to go like this. Yeah, you're just going to look at me reading it. Oh, sorry. Sorry about that. You're going to look at me reading it just because it doesn't seem to come up very well on the screen. And I spilled some coffee, but not on my clothes. So we're all good. All right. Here we go. Right. Okay. So let me just read out some things. So this is what the Court of Special Appeals indicated in their remand order. And this would have been on, what was the date of that? May 18th. They described what they were calling for in this reopening was, yeah, this is the kids' playroom down here. Yes, this is our basement. We're in the Midwest, so basements are someone said the baby. The baby's still at the hospital in the special care unit because she was a little early, but she's doing fine. I think she'll be out in a week. And we just go there during the day, especially my wife and I. It's close to my office. Anyway, baby's doing fine. Therese, Helen is doing really well. All right. I just had one, another child, our fourth, a week ago. So the Court of Special Appeals indicated in the remand order that, quote, a stay of this appeal and a limited remand to the circuit court is in the interest of justice. So, and they're deciding that. So what that means is, well, limited. And I read this as a lot more than limited. And here's why. When we get to what really opens things up, okay, petitioner also moves this court to reopen the post-conviction proceedings to allow him to raise the issue of cell tower reliability, which is not currently before the Court of Special Appeals. And the court, using its discretion, and when we talk about discretion, that means something that the court isn't compelled to do by the law, but can make a decision in the interest of justice. So that's a good thing in that the court is saying, hey, I wouldn't say that they're acting like a jury or a fact finder, but this judge is taking in and using his own discretion, his own beliefs, his own ideas, and not because he's compelled by the law in essence, and he's coming to the right decision. So that's what he said, and we're reopening the proceedings to allow cell tower reliability and supplement the record with relevant materials. So that's useful because that's saying that, we're not only going to just get the expert witness from before on the stand and have the state ask him questions and have Adnan Syed, his lawyer, cross. As I read when it says we can raise the issue of cell tower reliability and supplement with relevant materials, I read that to mean that this is the judge they pulled out of retirement. Yes, in response to the question. I read that to mean that they can have their own experts. They'll be able to have their own expert there who can educate the judge. Because the jury was never educated on this, and the judge hasn't been. And so I think they're going to be able to have an expert there and educate the judge. So that's huge. That's really, really, really big. Really big. And some of the questions you folks have all had about cell tower stuff, it's going to come out. Someone said about the state be accused of evidence tampering. Yes, and I think that can come out in this case. And the reason is when the next thing it says is the issue of cell tower location reliability is premised upon petitioner's claims of ineffective assistance of counsel. So that means that whenever Adnan Syed is talking about Cristina Gutierrez's failure to adequately cross-examine or do what she needed to do about the cell tower reliability, that's totally connected to the underlying issue of the cell tower reliability. So that expands things too, because we're not only talking about what the facts actually are. Yeah, they can question Asia about uric line. We're going to talk about that in question and answer. They can not only the facts about what the truth is about cell tower reliability, but what Cristina Gutierrez should have known or should have said, which is broader because we're getting into not only what is the facts, but what is a persuasive argument. Okay, and potential prosecutorial misconduct during trial. Potential prosecutorial misconduct during trial. You talked about evidence tampering. Well, is the court only saying in relation to the cell tower reliability? I don't think so. I wouldn't argue it that way. Let's see. And respondent can, of course, submit relevant materials. That would be interesting to see what the state would come up with. And it notes that the Court of Special Appeals also provided this court with the discretion to conduct any further proceedings it deems appropriate. So the Court of Special Appeals said, hey, trial court, you're the trial of fact. You can do a bunch more, and they are. Okay, so let's read the end. I'm going to read you the last two lines, because in these sorts of things, when you have a court order, you really want to pay attention to what the actual language of the order is, because that's what you're going to be quoting to say what you're allowed to do. And here's the actual language. So, it's ordered that the court shall limit its consideration to. Just note, it says shall order. People think, oh, this is limiting it, whatever. A lot of times when the court does stuff, it's careful to couch what they're doing as limited. And in one degree it is, but a lot of times there's a lot of wiggle room based on that. So it's ordered that the court shall limit its consideration to 1, McLean's January 13th, 2015 affidavit, McLean's potential, so let's just list this. In number 1, McLean's January 13th, 2015 affidavit, McLean's potential live testimony, okay, so her testifying live, and other relevant materials. So materials would be documents concerning, so we're breaking it down too, trial counsel's failure to contact McLean as a potential alibi witness, and alleged prosecutorial misconduct during the post-conviction proceedings. So when we're talking about prosecutorial misconduct that's going to be allowed to be discussed at the hearing, we have two types. We have, and someone said relevant as roomy, absolutely. And I'll if I don't explain that a little bit later, tell me. But prosecutorial conduct during trial and post-trial. So right now, number 1, we're talking about post-conviction. So that would be all the stuff that we think Uric did to mess with Asia, to put it colloquially. And 2, relevant evidence relating to. So pay attention. Relevant evidence relating to A, trial counsel's alleged failure to cross-examine respondents' experts on the reliability of the cell tower location evidence, and B, potential prosecutorial misconduct during the trial. All right. So, and the parties shall contact this court within 10 days of filing. What that means, just the final part, before I talk about part B, what that means is there's no surreply by the state. There's nothing more they get to say. They contact the court in 10 days, and these people set up a hearing date. Done. So 2, why do I think that number 2 is so broad? And let's just say, I'm not trying to be difficult. Someone says hiding the cover sheet. The words we use are important. That's why I'll never call it a cover sheet. It's not a fax cover sheet. It's a cover letter that was faxed. This could have been a letter from the president pardoning an Adnan that happened to be faxed. It's just the mode of delivery that's different. And I don't have criticism of Adnan's attorney, whatever. No, don't be sorry, because Adnan's attorney said the same thing. It's just a pet peeve of mine that when we adopt terms that not only are not the most helpful to our case, but actually aren't the most accurate. Because when I hear fax cover sheet, I'm always thinking of, just this cover sheet. Well, someone said faxes are legal documents. True. Anything's a legal document. But, typically I did, cover sheets in cases or see them, and it would be just like page 2 of 3. It would be meaningless, and you wouldn't include it as an exhibit. That's the part I'd say, because I read the cover sheet part when I first read it. I thought, well, yeah, you get stuff provided to you, and you don't necessarily include it as an exhibit because it's a cover sheet. It says, hey, Brendan, here's my signed signature page on an affidavit or on a declaration. I would not include that with the declaration, but it's very different. In any event, so we're talking relevant evidence relating to, and thank you whoever talked about relevant. I'm not going to go too far out on a tangent, but there recently have been changes to the federal rules of civil procedure dealing with discovery and e-discovery. I say that because I do it, I do it myself. And part of the way they changed things is they changed language that talked about like evidence tending to be relevant to a certain claim that wasn't, I won't get into detail, but wasn't exactly directly related to that claim in defense. And so it led to what many people think is wildly overbroad discovery and really the tail wagging the dog when it comes to a case. So it was a big deal. So what I'm saying is this relevant language, and whenever you say use the word relevant and say relating to, that's broad, roomy language. So we're talking about trial counsel's alleged failure to cross-examine respondent's expert on the reliability of cell tower location evidence. So that seems relatively narrow, but here's the big part. Prosecutorial misconduct during trial. It doesn't say prosecutorial misconduct directly relating to cell tower location evidence. So I'd run with that. And keep in mind too, when you're trying a case, arguing a case, there's the stuff that is directly related to the claims and defenses in the case, and there's stuff that's just helpful things you want to get in there. And that's important too. And maybe it's hard to kind of tie it to something, but it's very important. So that's where, if you think of it, the I'm going to kill note. Remember that? And I was really thinking about that because I'd never heard an explanation of the I'm going to kill note. We have had an explanation, and if you don't know it, we can talk about it, after. But I think Justin Justin knows his business when it comes to this, and I think it's going to be a fun hearing. I wish I could be there too, and it would be televised. I don't think it is going to be. But okay, I was going somewhere, and I got lost. Prosecutorial misconduct argument. Yeah, think about this for a minute. If you think about a case. Yeah, the kill note. Thank you. The kill note. So we have this kill note. The context of it is it was found in the back of some book from December. There's this back and forth. There's nothing, and they couldn't really do They even couldn't really do anything with it with trial if it was directly addressed. But it sounds really bad. So that would be the thing. If you're the prosecution, you want to get in. So there's lots of things like that are going to come out in an open hearing, and it's going to influence things. So yeah, I don't think this is going to be broadcast. Hopefully someone there, if you're going to be there, I'd love to, I don't know for sure about when she thought she was pregnant or what exactly it was, but it was on the back of the note. But if someone's going to be there, I'd love you to live blog it or something as it's going on, and I would love to, pass it along and tweet it and get it out there. So insofar as you're allowed to. Yeah, and it was the November breakup, like I said. So we're talking about where things are. So this is going to be wide open. They're going to have this hearing, and presumably Asia McClain's going to be there. And maybe we can talk about what the format of it is, just so you know. If you're okay with that, just so you kind of know what's going to happen and what to expect and why it's so big. It probably will be open to the public, maybe, but there's going to be a limit on how many people can be there. So unless... I want it to be on TV too. What time frame it could? I don't know when it would be. I'm guessing the state's going to delay, so it could be a few months out. Who knows? So here's how it's going to go. There's not going to be a jury there, right? So these are issues that are being decided by the judge directly. So I think Adnan will be there. So he's going to be, you're going to be in a courtroom, and I wish I had one in the background. The judge is going to be sitting where he's going to be sitting. There's going to be a lectern probably, and on one side is going to be the plaintiff, and the other side is going to be the defense counsel. And they're going to go up, and they're going to, maybe they're not going to say, may it please the court, but they're going to say something. That's what we say in appellate arguments. And they'll have some sort of opening, and at some point, depending on how many witnesses we're going to have, there's going to be witnesses that are going to come in. My guess is that The cell phone tower evidence part will be run a little bit like what's called a Daubert hearing. And a Daubert hearing is a Supreme Court case used, I doubt Urick's going to testify, someone's saying. Daubert's a Supreme Court case that's used to determine scientific reliability of evidence. And so you have witnesses and you have argument, you have cross-examination, and the judge can see it. And so there's probably, I'm guessing there's going to be something like that when it comes to the cell tower evidence. And then Asia McClain would be what you'd expect from a typical testimony that you would have at a trial. You would have presumably Asia McClain, it could go on for days, I'm not sure. Maybe it will, I hope. Asia McClain would be a defense witness, so she would come up, and sharing to Twitter from here isn't working. Well, all you need to do is, if you want to share this with other people, you just swipe to the left or right, up or down, and push share, the share button. You can do Twitter and Facebook. Someone said Adnan will be at the hearing. Yeah, it's a defendant's right to be in court, so he'll be there. He'll be there. Well, I'm sorry, it's not. Well, it's working for somebody. These things happen. But I think you already shared already, Sean. So, I'm happy. Once is enough. That's fine. So she'll have direct examination, and direct examination is just where you ask open-ended questions. Basically, you would say, well, what did you do then? And then cross-examination would be, as you'll see from my J cross-examination coming up on November 11th, would be, you went to the store, you went home, yes, no, at least that's the way it should be. Though some people say sometimes you can do otherwise. I'm going to write an article on that. All right, so someone said a ploy to get others to share, apparently. Anyway, so that's how that will. Did you not? Yeah, that's not the way I do cross-examination. No additional depositions allowed of Urick or anyone else. Yeah, not at that time. That's a good point. And that's Bill's Nailer. That's a great point. First of all, great news today, someone said. First of all, typically in criminal cases, they don't have depositions. That's more a civil case. I guess we're just kind of in question and answer, because I think, I kind of touched on it. We're going to have a toast. We'll have some question and answer. In a civil case is when you have a deposition, and a deposition is just a testimony in a more unofficial way. Well, unofficial in that it's not in a courtroom. It's done privately somewhere. As a result, there's a lot more arguments than in court because there's no adult in the room. Someone said, will Urick be there? I don't think he's going to be there. And anyway, so what the person said about depositions, touch upon, is so discovery is not reopened. And what I mean by that is other than what you can do kind of as anytime you can do with subpoenas or things like that, there's not a whole reopening of discovery. So it's limited in that way. It's not like we're going to call in everybody and start this whole thing over. Now you can't ask, will Urick be disciplined for his lies and cover-ups? Unlikely. There are what's called, someone asked that, there's what's called governmental immunities. And what that means is in most cases, you are, as a result of your acts as a public official, immune from personal liability for them. And so that's money damages. You wouldn't be immune from what's called injunctive relief. So if you were doing something bad, you could be stopped from doing it. Why governmental immunity? I don't want to get political. I'll just say this, I'll just say it this way. If you think about it generally, if I go down the street and someone robs me, it's called robbery, and they can be punished for it. If the government robs me, well, they could rob me of my land, and it's called eminent domain. So, yeah, and so there's some differences, but the point is that government and people who work for government are treated differently than regular people. And I think it kind of comes down to that. And in the old days, at some point, there was a complete absolute immunity. What effect, if any, does the fact that Gutierrez is no longer alive have on things? That might, Sato, thank you. That might have a good effect. I I'm very sympathetic. I worked for the government, but I don't think. Yeah. Anyway, I have different views, but I don't want to get into that. What effect of Cristina Gutierrez being dead? I think it's probably good for Adnan's case, because when you have a living attorney that's found ineffective, they have, in many cases, a personal interest in saying they weren't ineffective. You don't want to be saying this person's not only a terrible lawyer, but so terrible that if they represent you, it's probably going to violate your Sixth Amendment right to trial. So, it might be for the best. Yeah, it'd be great. I mean, it would be a Perry Mason moment, or a lot of moments, if he walked in, Jay walked in to trial. That would be great. Yeah, Cristina Gutierrez was a sad case. Can the government punish Urick? It's true. I mean, they could, but he was a district attorney. They're not really going to do that, I don't think. And this won't be good for his. Someone said Matlock. Yeah, my grandma used to watch that all the time. It won't be good for his his professional career. And I guess if things were bad enough, he could be subject to discipline by state. I think he's still operating in Maryland. I just say, yeah, someone wants him disbarred. Well, your feelings are shared by a lot of people. If Adnan ends up taking an Alford plea, he can sue the state, right? Can he vote, book deals? Yeah, I'm not sure about the Alford plea part. That would be something to talk to Colin Miller about. But I think he can still sue the state, which is, 1, 2, 3 questions. Yeah, we're going to have another 1, 2, 3 question. Yes. So, what is our 1, 2, 3 question? He's still part-time prosecutor in Cecil County? Are you serious? Urick is still part-time prosecutor? That's amazing. I had no idea, because if you look at his website, kevinurick.net, he doesn't say anything like that. And if you're on Twitter, some of us had some fun with that website. Even, I'll tell you, I write for a blog called Lawyerist. And you can see it. I don't know. I think some of the things I write are worth looking at. If you just put Lawyerist, Brendan Kenny author, it's in there. But we have something where we talk amongst ourselves. And I had that site, and I had the picture. If you look in the middle of the site to the right, that picture of that like Lady Justice thing, and people were just on the floor laughing. It's funny though. I said, yeah, that's from Kevin Urick's site, the guy that was the prosecutor of Adnan and the serial case. Like, you're obsessed with that, aren't you? I said, yes. But it's a good cause. So yes, great news, great news. Yeah, we're going to have a 1, 2, 3 question, because this is one probably many of you have, but the guess is as good as mine. So we're going to have a 1, 2, 3. And the 1, 2, 3 is, vote 1 if you think that Kevin Urick will be subject to some sort of discipline from like the court somehow. 2 if you think that he'll have to pay something as a result in one of these lawsuits. Pay something in one of these lawsuits, or have some effect on his professional law license. Or 3, if you think nothing's going to happen to him. So 1, the state's going to do something to him. 2, some effect on his law license. 3, nothing's going to happen to him. Ooh, there's some, yeah, so we'll see. Yeah, it should, yeah. So, yeah, civil lawsuit. Yeah, I'm embarrassed to say, I don't know exactly how it would play out. In a Section 1983 lawsuit, maybe for wrongful prosecution or something, but it would have to be really bad, to get damages. And the other things, the 3s are probably realistic. The other thing is, even if in some cases the person is personally liable, usually the state just covers it. Can Asia sue him for misrepresenting her in forgery? No. Yeah, I don't think so. Yeah, prosecutors are usually exempt except in very, very limited circumstances. So Asia can't sue him, and you don't want to go around suing things. It's probably just face saver for the state for Urick to remain immune. Yeah, I think so. That's what Sato said. I think that's a good point. So, his MO is all over other cases. Someone said this. I'm sorry. I'm having trouble seeing that. Yes, I think probably Kevin Yerkes similar to the. Oh, they forged the signature on an affidavit. Oh yeah, forgot about that. That's a problem. If you could prove it, yeah. Here's the thing. We're saying about what we know. Aren't attorneys bound ethically to uphold the law? Yes, we're officers of the court, but there's that and there's actually enforcement. You remember, I mean, just think back on the last episode about Cristina Gutierrez and think about what it took for the end to come for her. She kept messing up, and the court kept saying, well, she messed up, but it didn't harm the client. I mean, it takes a lot. It takes a lot to be disbarred. It takes a lot. Yeah, she got disbarred, but it took a tremendous amount. And what I'm saying is that I think the point I made before is, unfortunately, there's still not a great mechanism for the truth about lawyers and how good they actually are to get out to people. And that was a problem here. People on the defense bar thought she was still good. And, that's too bad. That's too bad. They thought it was too good. He had to write that affidavit. I need to revisit the affidavit thing. But, Yelp for lawyers. Yeah, there should be something better. But the prosecutors knew. So I think that Yerkes was much more bold in this case than in others because he had figured out what he could get away with. I mean, prosecutors talk. Would I like Jay better if he admitted to lying about all this? Yes. I mean, maybe like's the wrong term. And this isn't the place to talk about it. I'm probably going to talk a little bit about it on Monday to get ready for the mock cross-examination because I'm going to get a little bit into some of the Jay stuff to get you and me in the right frame of mind for the mock. And so I will say about the honesty part. About the honesty part, that it's interesting because Jay thinks of himself as a stand-up guy. That's a big part of his self-image. But he's very resistant, understandably, to saying that, he was wrong. The problem is he'd have to say that I was a teenager and the cops just beat me up. I might say stepping out, kind of maybe in there, but it's not going to be a big part. It's a great term. And you guys agreed. I did a poll on Twitter, and that was your favorite term from Cristina Gutierrez's cross-examination, stepping out. Well, I'm going to do another 1, 2, 3 poll because your guess is probably better than mine. Someone asked about time frame. So it's going to be 1, 2, 3. And one is that, we're just going to assume right now, Adnan's getting out, right? Can we all say that? He's going to get out. And so one, we're going to say he's going to be out. He's going to be out in 6 months. 2, 6 months to a year. 3, more than a year. So 1, 6 months. 2, 6 months to a year. 3, more than a year. So let's get your votes. Okay, we got some 1s, we got some 2s, 3s. Yeah, the thing is there's lots of 4s. Okay, we have a 4 somewhere. Cautious 2. The problem is the time frame involved. But I just think when you say, the idea is that there's nothing more powerful than an idea whose time has come. Our time has come. And so I probably put it 2. I see 6 months to a year, and he's out. So, 0. All right. Nothing in law is fast. Unfortunately not. All right. So, we've got those points. Is there any other questions that people have before I take you up and do toast? Yeah, Colin's got big bombshells. Yeah, I think he does. Adnan's not the only one in this situation. No, he's not. Yeah, I like that. I mean, the judge has no other cases. That's a big deal. That this judge came back. Why so hard to, thank you for that on talk. Why so hard to overturn convictions and introduce new evidence? Well, why is it so hard? Well, if you think it could cut both ways. In criminal cases, it typically doesn't, but in civil cases, it does. You need to have a one-time decision and have that be somewhat final, so that there can be you can rely on it, and things can be reliable, and things end at some point. So that's the idea of why it's harder to overturn something. But they should be ashamed, and it's a real problem. So someone said about DNA. Well, here's what's going on. I mean, I don't know exactly what's going on with DNA, but it's part of. Excuse me. Okay, how many days will the appeal take? First of all, it's not an appeal. What we're doing is we have reopened the case in a small way. So we have a trial, a mini trial going on. So we're taking issues of fact for the first time, not applying an appellate standard, and then eventually it'll get up to the appeals. But someone said that about the DNA evidence. Yes, DNA is a crapshoot, and it could lead. The problem is that when you have, I'm not a fighter or a boxer, but this is what I'm thinking of. Like, you've got someone in a corner, and you know that your right hook, or uppercut is what's you're winning with. You just keep going. You got them on the ropes, and if you keep going, you're going to win. And then you say, well, but I got this great left hook. Well, you don't want to go to the left hook necessarily. You want to go with what's winning. How's the new baby? The new baby is doing great. My daughter, Therese Helen Kenny, is still in a special care unit at the hospital because she was born at 34 weeks, 3 days, but she was 6 pounds, 3 ounces. She's doing well. I go into work. It's only 10 minutes away from my office. I bring my wife in, and my wife can hang out there during the day, and then she can come out. Yeah, Therese Helen Kenny. So Therese would be Saint Therese of Lisieux, some of you have heard of, and then Helen was my grandmother's name. So about about Dawn. I have a lot of thoughts about Dawn. There's a lot of interesting things going on. I'm going to be one of those guys who's referencing other stuff. If you look on, I have Catch. It's K-A-T-C-H. If you put in K-A-T-C-H Brendan Kenny, you'll come in my recorded talks, and I talk about Dawn under an emo thing and a few other things. So we're going to go upstairs. We're going to have our toast, and we're going to come back, and if you have a few more questions, fine. I'm going to play a song. What happened to all the Gutierrez money? I don't know. Okay. What happens after this trial is over, this mini trial? There may be a motion for a new trial granted. If there is, Colin's right. It won't be retried. All right. I'm going to turn the light on. We're going on a little... Sorry. We're going to turn a light on. We're just going on a little field trip upstairs because the toast that I want to give is on the wall. Sorry about the white noise. I've got kids, so we have white noise. Missed that Dawn comment. Dawn in the... I talked about Dawn in the in a talk that's on Catch. If you go to KATCH and then put in Brendan Kenny, you'll find the Dawn talk. It's an emo. Yeah, white noise is huge. So here's the blessing. So if anyone has a drink or whatever, I've got a beer. You don't have to have a beer. You can have whatever you want. I'm going to read this. So here's an old Irish blessing. And, since Adnan's religious or whatever, I don't think anyone would have a problem with the God part, but you can say your own blessing or whatever if you do. So, may the road rise to meet you. May the wind be always at your back. The sun shine warm upon your face. The rain fall soft upon your fields. And until we meet again, may God hold you in the hollow of his hand. So it's an old Irish blessing. And the family and everyone else in this case. This is the time. This is the time when everything's changing, and when to take a quote from the Psalms, when the hungry are given good things and the rich sent away empty. That's where we're at. That's where we're at right now. So, we're gonna put this on. Multicultural and inclusive. That's what I'm trying to be. I'm not. Anyone can have their blessings and everything. I'm not trying to take everything away. Someone said Psalms quote. It's also the Magnificat. All right. So here we're gonna have a song. If unless some of you have some questions, we're gonna end with a song. And just a minute. Oh. Okay, I'm just having a problem. All right, we're gonna end with a song. All right. Any more questions before we end? All right. Everyone's happy. People are having chocolate. People are having whatever. This is a song. All right. Thank you for. Okay, so we're ready for the song, and then we'll be done. All right. Good. Let's do this. This is one of my favorite songs ever. I hope you like it as much as me. Oh, here we go. Ah. Ah. Peter Gabriel. Well, if it's copyright infringement, they can sue me, right? And it's on YouTube. Home, Adnan! We're all going to have a concert when Adnan gets out. It's called Salisbury Hill. night, everybody.